Welcome, everyone, to the webinar on transboundary aquifers between international water law and the human right to water. This webinar is organized by Dr. Imad Antoine Ibrahim in collaboration with the Earth System Governance Project. So thank you for joining us today. It is our great pleasure to host this event as part of the South-South series, which has been launched in March by the Earth System Governance Project. The Earth System Governance Project is actually a global interdisciplinary research network that is advancing knowledge at the interface between global environmental change and governance. The project aims to explore political solutions and novel, more effective governance systems to cope with global environmental change. It actually connects and mobilizes scholars from the social sciences and humanities, working from local to global scales. The three main aims of the project are to expand the global mobilization of Earth system governance researchers, to stimulate and facilitate research collaborations, and of course to inform and advise at the science policy interface. So as mentioned earlier, the event is being organized as part of the South-South initiative, which aims to foster further the network of scholars based in or from the so-called Global South, working in the field of Earth system governance. This initiative has started a year and a half ago during the annual conference of the Earth System Governance Project, and currently serves to increase research exchanges, address regionally relevant topics, and strengthen the network worldwide. So the three aims of the initiative that has been launched is firstly to design regular virtual workshops and webinars, such as this one, for scholars from or based in the Global South. The second aim is to organize a day dedicated to South-South dialogues with researchers from and based in the Global South during the upcoming conference on Earth System Governance, which will take place in the Netherlands at Radboud University. And is actually a call for a special issue in the Earth System Governance Journal. This call should be by the end of 2023, following the annual conference, and the special issue should be released in 2024. So the Earth System Governance Journal is actually a flagship publication of the Earth System Governance Project. It is an open access platform for research on governance and institutions in the context of environmental change and Earth system transformations. And it has actually recently received an impressive impact factor and became a leading Q1 journal according to the GCI classification. So before giving the floor to Dr. Imad Antoine Ibrahim for his presentation, I'd like to briefly introduce his work. So Dr. Imad Antoine Ibrahim is an assistant professor in environmental law and governance at the Department of Governance and Technology for Sustainability of the University of Twente in the Netherlands. But he has been working on global issues from a legal perspective for the past 10 years and is currently involved in several projects in various places such as Europe, South Africa, the Middle East and North Africa region, but also Central Asia and China. In the past, he was a non-resident research fellow at the Center for Innovation in Gas Research and Utilization and Institute of Water Security and Science at West Virginia University in the United States. He was actually also a visiting researcher at the Environmental Law Institute in Washington, D.C., a junior fellow in the Global Research Network think tank in the UK, and an early stage researcher at the Dutch Research Institute for Transitions, based in Rotterdam in the Netherlands. Prior to this is also, actually he's still currently a resident research fellow at the Center for United Nations Constitutional Research, which is based in Belgium, in Brussels, and an energy policy expert at the Lebanese Oil and Gas Initiative in Beirut. He also worked as an EU Commission Marie Curie Fellow at Tsinghua University School of Law, the Center for Environmental, Natural Resources and Energy Law, at the Chinese Research Academy on Environmental Sciences in Beijing, and at the Business School Research Center for Climate Change and Trade at the Beijing Normal University. He also worked as a researcher in several European and Italian institutes and universities, and was also a trainee lawyer at Al Jad Law Firm, reviewing international conventions related to energy. His background is that he holds a PhD actually in law from the Institute of Law, Politics and Development, Sant'Anna School of Advanced Studies in Pisa, Italy, and also got a master in European Interdisciplinary Studies from the College of Europe in Belgium, and a bachelor in law from the Lebanese University, Filière francophone de droit in Beirut, Lebanon. We're really excited about this presentation today. We would like to thank Dr. Imad Antoine Ibrahim for organizing this event, and I will now hand over the floor to him for this presentation. Thank you.
Thank you very much for the introduction, and I'm just going to share the screen. Okay. So we're going to start from the beginning. Actually, the topic of today would be the outcome of a book under contract with Routledge on this topic. So the transboundary aquifers between international water law and the human right to water, and I might add sanitation. The first question one might ask, what's the connection between these two? Because each term here has a certain meaning. The first thing we're discussing is transboundary aquifers. Why the focus on aquifers that are transboundary? By aquifers, these are, for those who don't know, aquifers are geological formations where groundwater usually is. But why the focus on transboundary? It's because international water law addresses or focuses on water shared between countries, surface water and groundwater. In this case, the focus is more on groundwater located within aquifers. That's why the focus is on transboundary aquifers, where legally it has a different legal nature than one would say aquifers located within national territories or at the domestic level. So that's the first distinction. The second distinction is the focus on aquifers and not surface water. Surface water and groundwater have, although they belong to the same legal regime, which is international water law, they are sometimes subject to different regulations, or at least we are trying to subject them to different regulations, taking into consideration the difference between groundwater and surface water. That's the second distinction. Finally, the human right to water and sanitation. This human right has been extensively, to a certain extent, analyzed for water at the domestic level, and in several articles for water when combining it with surface water in the transboundary context. But very few articles focused on the human right to water and sanitation in the context of transboundary aquifers. Why this is important? It's because groundwater has, or is considered as having a better quality than surface water. We're talking about drinking water. And it requires less treatment. Yet, when we try to understand the interplay or the connection between transboundary groundwater and the human right to water, you could find very few articles on this. It's in this context, I actually pursued my entire PhD on this topic, which is the subject of today's presentation. So the general question that we are asking is the following. Can synergies be created between international water law? Why the focus on international water law? It's because groundwater is part of international water law. Can synergies be created between international water law and the human right to water and sanitation? Why are we discussing the term synergies? If we go back historically, international water law and the human right to water and sanitation were developing in parallel. They are not connected because the human right to water and sanitation belongs to the category of international human rights law. That is different than international water law addressing transboundary water resources. So after the Second World War, efforts have been made to develop two distinct legal regimes at the same time. resulting in being in 2024 in a situation where we are asking ourselves, actually in the last decade, hold on a minute, can we create synergies between these two? Or should we actually create synergies between these two? Well, in terms of transboundary water and the law, so what are, if I want to take, we're discussing here the background. If you forget everything and try to focus on the concept of fresh water, more or less in the global scope, we have three types of fresh water globally. We have groundwater, we have surface water, and we have water that is trapped in the polar ice. 97% of water on Earth is considered salt water. 2% is trapped in the ice, in Antarctica and in the Arctic. The 1% remaining, we have out of that 0.7% groundwater and 0.3% surface water. Lawyers came in along geologists and they started discussing this. Okay, in the transboundary context, so we need to regulate this 1%, where 2/3 of it is groundwater. Based on that, an entire legal regime was created to that end over the last 50 years by different institutions, which we will discuss now. So these are the three main sources of fresh water in the world, in the transboundary context, but also generally. Lawyers globally had to regulate this in the transboundary context because domestically, each fresh water at the domestic level belongs to the state that can regulate it. So why this is important? Because the problem is not only legal, it's actually more or less political, because when we discuss international law, in this case, public international law, one would say, or we consider, or we say in general, that public international law is political by nature. What do we mean by that? It's made for political reasons by politicians who send experts to do that. Given this reality, and if I go back a little bit, plenty of suggestions were made here to understand how to regulate groundwater and surface water in the transboundary context. And that these suggestions were made over a long period of time. A little bit of more background. Any legal regime will follow, the development of any legal regime will follow the technological development. So what we now consider as technology we use to treat water or try to find or exploit water resources did not exist in the 50s. Naturally, legal experts in the 50s adopted rules or instruments for fresh water that did not take it, that evolved over the years and the decades, considering technological developments. The main focus initially was on surface water. Why? First of all, you could see it. And it was more relevant and important than groundwater because we did not have the scientific understanding of its importance or its actual quantity. This is why initially lawyers or regulations were tailored more or less to surface water. We will come back to that, but keep that distinction in mind because the extreme or the primacy given to surface water initially affected the development of laws and regulations for groundwater. In fact, groundwater in the initial instruments was only mentioned if it's connected to surface water from a hydrological perspective. Meaning, if I have a river and this river provides water to a groundwater beneath it, then that groundwater was considered as within the scope of that instrument. If there was an independent transboundary groundwater source, it was not going to be considered initially. All of these things affected the regime that has been developing over the years for the regulation of transboundary groundwaters included within aquifers, in this case, transboundary aquifers. So what are the instruments adopted? First of all, we need to differentiate two organizations. International Law Commission, the ILC, International Law Association, ILA. The International Law Commission is a body established by the UN to adopt rules and conventions. The ILC managed, after years of negotiation, to adopt the Convention on the Non-Navigational Uses of International Watercourse, what we call UNWC, in 1997, to govern surface water and certain groundwater resources that were included. Similarly, the ILC adopted what we call United Nations, the Helsinki Convention or the Helsinki Water Convention in 1992. Difference. The main difference here is the second one, the Water Convention, was regional, only applied to Europe, and only recently, in 2014, became global. Initially, the first convention, the UNWC, was the only global convention until things changed with an amendment. Right now, we have two global water conventions focusing mainly on surface water, where groundwater is included in both, but some types of it are excluded from the first convention. Yet, in both cases, we don't have any provision taking into account the characteristics of groundwater that are different than surface water. This is why, in 2008, the ILC adopted the draft articles on the law of transboundary aquifers. This instrument only addresses transboundary aquifers or transboundary groundwaters. It does not take into account surface water. Yet, for the time being, it's not binding, meaning it's not obligatory. Besides the ILC, we have what we call the ILA, the International Law Association. The ILA adopted different instruments. None of them are binding because they are simply instruments, and they served or paved the road for the International Law Commission to adopt the conventions and the draft articles. I'm not going to go through these, but these, like the Helsinki rules in the 60s, Seoul rules in the 80s, Berlin rules, as an update to the Helsinki rules in 2004. But I'm not going through these things now. So we have these instruments. Over the years, practitioners studied them and found actually that they have gaps. There are gaps in these instruments. Well, firstly, you have different provisions within these instruments that sometimes either overlap or clash. Hence, how do we deal with that? Suggestions were made to create harmony or harmonize all of these instruments together. The first suggestion was, let's adopt the draft articles, which is this one, the draft articles, as a convention. Since it's still non-binding, let's adopt it as a convention addressing all kinds of groundwater. This can happen, as so far we are negotiating that. The second suggestion, let's amend the first convention, which is the one adopted in 1997, to consider groundwater, because in this convention, there are no provisions specific, tailored to groundwater resources. So far, we have two suggestions. Third suggestion, let's adopt the draft articles, the one that is non-binding, as a protocol to the convention, 1997 convention. In a way, the idea would be to harmonize these two conventions. And finally, and since that transboundary groundwater is a very sensitive issue, why not keeping the draft articles as a guiding principles? Non-binding, states can use it to manage the water in a transboundary context, the groundwater resource. And that would give them a lot of flexibility. These are the four suggestions made, hoping to address the issue of groundwater resources, or trying to harmonize transboundary groundwaters with the rest of the international water law regime. Each of these suggestions has pros and cons. Each one of them has been studied extensively in the last 20 years. Right, so far, we've seen the development of international water law concerning transboundary aquifers where transboundary groundwater law is located. So we have international community trying over the years to adopt instruments focusing mainly initially on surface water and then having conventions tackling both but with no provisions tailored to groundwater, then adopting an instrument in 2008 only on groundwater and then thinking, wait a minute, we need to harmonize all of these instruments together. Well, after all of this, one has to ask the question, what is the legal status of transboundary aquifers? Should we consider transboundary aquifer or transboundary groundwater as a common good? If it's a common good, then it has to be managed in a common way between the states that share it. Is it a private good? Should states have the ability to extract groundwater in the way they see fit? And hiring and having private companies do so? That would create a lot of problems. Is transboundary groundwater a human right? What does that mean? A state is in severe need for human right for groundwater because for some reason there is drought, so they can use all the groundwater and not allow the other state of using the same resource in a transboundary context. Should that be allowed or not? And finally, should transboundary aquifers be considered as a quasi-commodity, meaning they need to be considered as a human right because you need water access, but water access cannot be provided for free because you need all the infrastructure in place to ensure that this groundwater reaches home. So in a way, it's a commodity, but it's not a commodity. All of these elements were discussed to try to understand what's the legal status of transboundary aquifers? How do we consider it? So you have the international legal community discussing how to adopt conventions to address transboundary aquifers. And then you are wondering, what is the legal status of transboundary aquifers? Then we have the third question. Well, meanwhile, when these two things are happening in the same time, you have another part of the international community focusing on the development of the human right to water and sanitation. So you have three angles in the same time. The development of the human right to water and sanitation happened over decades. The right to water was never mentioned in the conventions adopted after the Second World War, but since these conventions contained rights that were not considered exhaustive as a list, water was considered to be mentioned indirectly. Efforts were made since then and somehow it was mentioned in some of the conventions, until 2002, when we had a general comment 15 on the right to water, where the international community discussed this right in details without adopting it yet, however. The adoption of the human right to water and sanitation took place in 2010 by the United Nations General Assembly and the Human Rights Council. Questions were risen from then. How do we implement this at the national level? How do we implement this right outside the borders, meaning the transboundary context? You have, for instance, a transboundary groundwater between three countries. How do you implement a human right to water and sanitation between three countries sharing the same groundwater resource, or even surface water? All of these questions were asked. Upon examination in the transboundary context, I found the following limitation of this right. First of all, the right is not binding in international law. In other words, having a right to water per se does not guarantee its application because it's not being adopted as a convention. And anything that is not adopted as a convention or a protocol is not binding. It has a moral power, politically as well, but not legally. Secondly, assuming it's binding, assuming it has all the power that we want to have it. How do you implement it in practice? How do you force a state to implement or to respect a human right to water and sanitation? You can't. Thirdly, water cannot be seen only from a human right perspective. It's unique, it's special, it's a finite resource. It requires different consideration. Based on that, only efficient regulations can ensure water access. So let's go back a little bit. You have international legal regime applicable to transboundary groundwater resource, trying to protect this resource. Then we were discussing what is the legal status of transboundary aquifers. And then we try to involve the human right to water and sanitation, where there are many problems trying to, and if we try to implement this right in the transboundary context. Now, if we try to make a comparison between international water law and the human right to water, we see the following. International water law, meaning the conventions that I mentioned before, and even the draft articles, the one that is non-binding, mention what we call vital human need. In one of the provisions, they mention vital human need. In a way referring to human right to water and sanitation, but without referring to it. Why? Because these were adopted before the human right to water. So we have this concept of vital human need within international water law, and we have the human right to water. So, and we create synergy between these two. Well, first of all, we need to create synergies. Why? The concept of vital human need adopted within the provisions of the conventions is limited in its scope. It covers specific needs that a state should provide. Meanwhile, the human right to water and sanitation has a broader scope. The state has more obligations to use. Secondly, in several water treaties, for instance, the Senegal Water Charter, they include a provision where they consider that states and their practice, when they try to exploit the transboundary water resource, they have to consider the human right to water and sanitation. As such, this is becoming a state practice. Finally, if you include this right as a provision within conventions and treaties, you give this right a binding force, which it doesn't have at this stage, given the limitations I mentioned earlier. So for all of these reasons, the suggestion is, if we want to create synergies between transboundary aquifers and the human right to water and sanitation, is to include a provision within water treaties in the transboundary context that takes into account or focus only on the human right to water and sanitation, so that states, when implementing this treaty, takes that into account. They have an obligation within a water treaty that considers the human right to water and sanitation for its citizens, or the citizens of the three countries in general. At this stage, we have an opportunity at the international level to do that within the draft articles that only focuses on transboundary aquifers. Again, this instrument was adopted in 2008, and until now, it's still non-binding. So we could still amend this instrument to include a provision where it only focuses on the human right to water and sanitation, replacing or eliminating vital human need, and then discuss. Do we adopt it as a protocol? Do we adopt it as a convention? Do we keep it non-binding? That's a different conversation. But we have an opportunity to create synergies between these two legal fields at the same time. Something that for the time being is not happening. And let's say these synergies are created. Well, then one would wonder, do we need to update existing water agreements adopted in the last century, or do we only focus on new agreements? And is this feasible in practice? What are the most likely implications of doing so? So far, we don't know. But what's the alternative? Not considering the human right and water and sanitation in the transboundary context? I don't think that's a wise alternative. Thank you very much, and I'm looking forward to your questions.
Many thanks, Imad Antoine, for this presentation. I would first like to ask the audience if you have any questions for our presenter today. We'll still have 30 minutes, which gives us the opportunity to really engage in this Q&A session. So please feel free to raise your hand or leave a message in the chat if you have any questions. If you don't, then I'm going to go ahead because I do have a few questions for you, Imad. The first question, especially because this topic is a topic that is not really tackled, and we were wondering if it is a topic that really requires also interdisciplinary research in that sense, that you do need to create more collaborations with, for instance, natural scientists to really look at also the specificities of different regions. Is the interdisciplinary approach something that you would recommend for conducting such research?
We already know from scientific approaches that the quality of groundwater is far superior to surface water. So in its current state, if you extract surface water and you extract groundwater, groundwater is more readily available for drinking than surface water and requires less treatment. So if one considers this element, we will need more scientists to prove why the quality of groundwater is more important, and why it requires that kind of consideration from a human rights perspective. Because if you take a river, the river, you might have ships, even if it's fresh water, navigating it. You might have other elements. Meanwhile, groundwater remains untouched. Scientifically speaking, we need more of. We need the regions you mentioned. I would say a focus on quality of the water itself as groundwater, a focus on the scientific approach is very much needed when you discuss the difference between chargeable and non-rechargeable aquifers. So you have groundwater resources where you extract it and it's recharged, and other groundwater resources, we call it fossil aquifers, they are non-rechargeable. So you will need scientific expert, and by default, once you start extracting groundwater from the non-rechargeable aquifers, there is no sustainability. You are actually depleting the resource. Then you would need scientific understanding of, well, how much we should extract in a way that to provide the human right to water and sanitation, but not deplete the resource. We have no idea. Should we do that? That's also a question to make. I have no idea. A second topic that, first, I did some work on that is the conjunctive management of fresh and of surface water and groundwater. In many places in the world, you have a river that is connected to a groundwater beneath it. And so if the river is polluted, so is the groundwater and vice versa. Well, then the question, how would that affect the human right to water of both cases? And how would conjunctively be able to manage these two resources in the same time? More scientific research on that is needed. Legally speaking, we have nothing on that in place right now. That's but we need, the problem is, and if you go back to study the history of how international water conventions were adopted, hydrologists and scientists had miscommunications with lawyers, and that miscommunication affected the adoption of the instruments in the sense same terminologies meant and still mean completely different things to both disciplines. So the term aquifer for a hydrologist is different than what it means for a lawyer. And that's where the entire contradiction comes in this regard. This is more or less the problem so far. And to answer your question very in summary, we need more of a conversation between scientists and lawyers, which is now not happening that much, unfortunately.
I will come back with another question because thank you so much for your answer. But I see right now that we have a question from Grace in the chat, asking whether synergies are synonymous with coherence in this case.
What do you mean by coherence, Grace, in this case? Why I cannot see the chat? I'm trying to. Okay, yes.
Grace, feel free to take the floor if you wish to.
Because I need to be able to.
Hi, everyone. Can you
Hi,
please
Grace.
hear me?
Yes.
Okay. Oh, the reason why I was a little bit curious is I wasn't too sure about the definition for the synergies, what exactly you meant by the synergies, because also I think why I couldn't really understand the synergies, I also missed, I think, on the method you used to analyze the human rights laws versus the aquifer, whatever laws, because previously I've heard about coherence, so I was wondering, is it the same thing or is it a different thing?
I would use the term harmonization of international legal regimes. So how do you harmonize a human rights regime, in this case, human right to water, with another existing regime that is international water law applicable to transboundary aquifers? Why we try to harmonize them? Because at the international level, we have what we call fragmentation of international law to different fields and subjects, taking into consideration technicalities and other elements. So we try to harmonize fields that are affecting the same thing, basically. And for now, this is not the case, at least between these two elements, whether it's the human right to water or transboundary aquifers. Why we try to do that? Because the human right to water is implemented, in this case, in a transboundary context. So we're trying to harmonize or make sure, in this case, that the human right to water is indeed implemented in the transboundary context, considering international water law. Because international water law is applicable there, so we better try to do something in this regard. That's more or less, I hope this is clear, Grace. If not, I can clarify more.
Yes, it is. Thank you.
Sure. Yomiko?
Imad, do you have access to the chat? I see we have
Yes.
additional questions in the chat.
Wait, there's a.
Would you like me to?
There was Yomiko. I don't know if it's. There's a hand raising.
Yeah. Hi. Hi.
Hi.
Hi. Yeah. Thank you very much for this presentation. My question is that so I understand about this, like this importance of synergizing. What are the more practical ways to integrate this human rights approach into the transboundary legal like actual texts? Is there like a kind of concrete suggestion to how it is? Because like there are, certain, because I've been working more on the international water law side myself, and we've also developed together with UNEC like the practical guide for developing, and then we have concrete examples. And if you have any suggestions to how human rights approach can be incorporated, that would be
There are specific treaties. Thank you for the question. There are specific treaties in place that the human right to water and sanitation is adopted as a provision. So if you take, I think it's either the Senegal or there is the Senegal River Charter, and there is a second river charter in Africa. One of them or both of them include a provision on the human right to water and sanitation. The idea is for the states to consider among all the, so that it's like you have a treaty for the Senegal River and in this, or the Niger. So it's either the Niger or the Senegal River. You have two treaties, one for the Niger and one for the Senegal River. One of them, or even both of them, include provisions on how to share this water resource. Within these provisions, you have one provision only concerning human right to water and sanitation, that states have to observe this human right to water and sanitation when implementing this treaty. What does that entail? It means that this provision will need to be read in conjunction with other existing provisions within that treaty, mainly the principle of equitable and reasonable utilization and the obligation not to cause significant harm. The principle of equitable and reasonable utilization states that each state utilize the water shared in an equitable and reasonable way. And then, while using the water, it should not use it in a way to harm other nations. Now, but then now we open the Pandora box. How much water should be considered a human right so that a state can extract it in a way that is equitable? We don't know. So even as having a provision within the water treaty does not guarantee per se that this can be implemented in practice or it will be implemented effectively. But what else you can do? Adopt a more detailed provision saying, well, we want to consider the human right to water in the transboundary context. This is in details what that means. Each state has the right to extract a certain amount of this water for the human right purposes. Maybe. Should we include industry in that? Yes. Is that also drinking water? What is the human right to water? What definition do we use? We don't know. So do we have examples legally? Yes. How do you implement them in practice? I have no idea. Because even the provisions of existing treaties are difficult to implement because they are subject to the interpretation of each state. Even the most basic ones. For instance, states needs to share water in an equitable manner. What does equitable mean? Every state has a different definition, interpretation to the term equitable. How do you compromise? Once you have, it's political. States have to agree on that. So, but this is the reality. I hope this response is sufficient. Yomiko?
Yeah, okay, thank you very much. We very much look forward to having some days more concrete understanding in terms of, yeah, I understand like in the legal context, you can't really put too much detail in that. And I think that's the challenge, but thanks a lot. Helpful.
The problem of the issue of transboundary water is that cooperation is the exception, not the rule. Even if you have a treaty, states water is a sensitive topic. So they try to pretend that they will apply the treaty, but it's not always the case. There is another question about what is the nature of water? Is it a private good? Is it a common good? It's a quasi-commodity. When I wrote this chapter for the book, I reached the conclusion is that is water, and I was discussing this in Geneva because they were discussing water as a human right, and I had to stop them. Hold on a minute. Yes, great. Let's say tomorrow water is a human right. Great. We all know water is a human right. What does that even mean? How do you need to provide access to it? Thus, just going on the street and say water is a human right, I want water in my house, guarantee that water will reach my house or the household? No. So how do you provide access to it? You build infrastructure. You ensure that this water is constantly treated. You have personnel working on it via either public administration or private companies. All right, all that costs money. Who's going to pay for that? The individual, maybe. The state, via imposing taxes on the individual, so that we can open water at we can have access to water at our houses. So if that is the case, how can we say that water is a human right? Even if it's a human right, you need to improve it. You need to ensure access to it. So it's not only a human right, but cannot only be considered a commodity, because then it's subject to market regulation, and anybody can, anybody can actually put the price on water that is extremely high, that people cannot afford to do it. And indeed, in some countries in Latin America, in the 90s, they privatized the water market, and companies started selling water at a very high price. And then, hold on, the poor people could not buy it, and then the state had to intervene. So on one hand, you need infrastructure and constant stability, people, personnel, technology to use to ensure that water arrives at homes and everything else. But on the other hand, that costs money. But on the other hand, you need to consider it as a human right so that people can have access to it without being subject to market rules, to extreme market rules. How do you do that? You consider water as a quasi-commodity. That is a human right, but not completely a human right. That is a commodity, but not completely a commodity, something in the middle. Unfortunately, but this is the case.
Thank you, Doctor.
Thank you, Imad. I'm just actually, based on this question, I was wondering, do you think that, because you mentioned the charter in Senegal and many and other countries about the human right to water, do you think that these national frameworks are actually like complicating the international debate? Because when you have this on the one hand, and for instance, a fully privatized water in Chile, for instance, on the constitutional level, does it have an impact on the international debate? Do you think that it creates more complications in a way?
Just to point out that the Senegal Charter, its name comes from the Senegal River. So although it's the Senegal Charter, it's shared between several countries. So the charter itself is it's transboundary. Same with the Niger River that is shared from within different countries. So they call them Niger Charter or Senegal Charter, but in fact they are charters signed. It's like a water agreement between several countries. So this is important to point out to that. So if you take that into account, how would you reframe your question?
Yeah, no, in this case, indeed, we already have an example of transboundary agreements. So then I'm going to follow up with another question I wanted to ask earlier. Do you think that on a regional level, it is easier to actually come up with a debate and with an agreement on the use of water, on the human right to water? Do you think that the global scale is, in that sense, realistic?
Let's say that tomorrow all the states got together and decided, well, magically, that they will all vote for a convention on the human right to water and sanitation that entails specific rights and obligations, which are already mentioned in the human right to water adopted by the United Nations. First question we would ask is this convention targeted at the national level or a transboundary context? And if it's targeted at both cases, who's going to implement it? Upon studying international law and trying to understand why some conventions are efficient and other conventions are not efficient, I came to the conclusion that is the following. A convention is efficient is when a state or a group of states outweigh or analyze the pros and cons of being part of that convention, and then decide, well, the pros outweigh the cons, and based on which we will actually implement the convention at the national level, and we will abide by its rules. Examples, to a lesser extent, is international trade law. A state or states in general abide by international trade rules because trade has an intrinsic value to each state based on which they need to trade between countries for economic growth and to make sure that exports and imports happen. That is the value given to trade. Now, when it comes to water, water is still not seen, at least in the transboundary context, though, as if it has a global value that requires that states share it accordingly, but rather it's still seen as in an individual manner that this is my water, be it at the national level or be it in a transboundary context. How do you, now one might argue in this case that it's easier to implement a human right to water and sanitation in the transboundary context because implementing an agreement requires that all states compromise and say, I will implement it. So if one state decides to implement the human right to a provision on the human right to water in the transboundary context, that creates an obligation of reciprocity on the other nations to do the same. Hence, in a way, it may be easier because at the domestic level, you cannot control the state. You have a river that crosses one country. How do you have a convention at the international level? Great. How do you implement it? How do you force a state to implement the convention, the human right to water? The only way is to have a group of activists and lawyers making sure that this right is included within the constitution and domestic laws, and then going to the judge and telling the judge that, well, look, this is my right being violated. Give me indemnity or compensation or whatever, or deal with the situation. This has happened in other fields, such as international climate change law, for instance, in the Netherlands, where some citizens saw that state is not doing enough, and they went to the judge and told them the state is not doing enough in accordance to whatever written domestic regulation and EU law in the Netherlands and whatever the Netherlands committed itself by the UNFCCC and the Paris Agreement. And they got a ruling in their favor. And I think in many cases, we got these kind of rulings at the domestic level in many countries for water, because water as a right is included in many constitutions, and I think in at least half the constitutions globally. The other way, some people were discussing, let's consider water as a common resource of human mankind, meaning it should not be left to be managed by the state, but to the international community, even at the national level. Is this realistic? I'm not so sure of that. But these are the suggestions in place, considering the reality, and it's not easy. Look what happened in Syria, for instance, when you had the conflict between Turkey and these rebel regimes that were in the liberated area of Syria, where they did not subject themselves to the political situation in Turkey, and so Turkey stopped the water from coming to these Kurdish areas, although this is their right. It's a transboundary river there, and they should have a right to have the water, but Turkey stopped the water from coming. Is this a ground for intervention to the international community? Maybe. How about when ISIS in Iraq threatened to blow the entire Mosul Dam? Is this a ground for the international community to intervene? Also maybe. So I don't, given the problem of international law is that you cannot implement it by itself. It's based on state consent. If it's even, so the state has to be willing to implement the regulation or whatever treaty they sign and ratify. Otherwise, you cannot force it. Otherwise, if you try to force it, you risk war. That is it's a one pessimistic or realistic view on the situation, that no matter what convention or what instrument you adopt, it's up to the state to implement it. And if the state does not implement it, the only thing you could do is exercise peer pressure, based on which the state might think twice before not implementing things. But that's the only instrument we have in hand.
That's very interesting, Imad. Is there any other questions before I follow up very quickly on one thing? Or I don't see any questions in the chat.
For the slides, somebody saying sharing the slide, I will not be able to share the slide yet because it's copyright, intellectual property. This is going to be out as a book with Routledge in the next few months. Again, it's based on my PhD, so I'm still waiting for the final proof. And once I have the book out, I will share it with everybody as well. But that's for that reason I cannot share the slides at this time.
Thank you so much. I see we have 4 minutes left. Any final questions? I don't see any. I'm very interested in this conversation. Thank you so much, Imad, for taking the time to answer these questions. I guess let's hope for a transboundary agreement. Let's and for also like a great way to implement it and report other countries to ensure that this is binding enough. Because I guess that's also the main question: would such an agreement be sufficiently binding?
It's not the binding part, it's the state's willingness to implement the agreement. You can adopt a binding agreement. Well, then what? If a state does not implement it, what do you do? All right, you go to the ICJ, you complain that the state is not implementing it, and then, okay, you get a ruling from the ICJ that the state is not implementing it, and then what? What do you do? If the state still does not want to implement it, what? You go to war? You cannot risk that.
Yeah. Do you think it will lead to potential conflicts in the future? This very crucial topic.
It's already leading to conflicts. Look at on the dam between Ethiopia. What was the name? Renaissance Dam between Ethiopia, Egypt, and Sudan. They don't even know what to do with that because the dam they're trying to and it's look at the situation in the Mekong between China and the rest of the countries there. You had each country you had the Mekong agreement. China and Myanmar is not part of the agreement. Each state creates dams that stop the other state downstream from benefiting from the water. Different organizations, MRC, Mekong River Commission, Langkang Mekong Cooperation Mechanism, they create different mechanisms, try to develop their own interests. And so it's already, and that's just one basin in the world, not taking into consideration other basins. Same in the Nile, same in the Arab countries, same and for the Guarani in Latin America, Southern Africa as well. They had the protocol for it's complicated everywhere because water is sensitive. Everybody wants to use it. And it's going to get more sensitive when we consider the use of big data and technology. Artificial intelligence is getting into the topic. You have, for instance, technology. You have big data is being used right now. Satellite surveillance. You assess the data concerning the water resource, and you make expectation for the next 10 years. Climate change will affect water in this river to that extent. It means that states have to reduce water allocation. Which state in his right mind will reduce the volume of water that they use every day because of that? Nobody. They will actually question the scientific results. And that's what happened in Southern Africa when we used big data to try to come up with scenarios and further information for policymaking. The problem is political and will always remain political.
Thank you so much. I guess we're all very much looking forward to your future publications. I'm gonna switch on my camera to also indicate to everyone that to know more about Imad's research as well as the Earth System Governance Project, you can visit our website that is currently on my background. And Imad, I really hope that we'll be in touch in the future and that you will let us know of any publications, further research that you're conducting, and we will make sure to, of course, promote this incredible work that you do at the interface of international law and the human right to water, and of course, additional research that you're conducting. So thank you so much, everyone, for joining us today. Do not hesitate to reach out to the Earth System Governance Project if you have any further questions. As Imad indicated, the slides won't be available, but the recording will be made available in the future, and that will be on our website on the webinar's webpage.
I also remain available. I mean, my email I think is there somewhere. If you have any questions or you want to discuss any topic related to water or other natural resources, I would be happy to do that. So yeah, as well. And yes, Camille, hopefully we meet soon as well in person and we collaborate on other issues.
Thank you very much, everyone. We wish you a great day.